Tonight is the 38th annual DC High Heel race on 17th Street, and I'm excited to see how the new cast does in this race. Betting has already started. Odds are good on Levitt, Gnome, and Hegseth. Obviously, Melania will place. That woman has been in heels since she could toddle, but I'm worried about Damo getting into those Louboutins this year. I think Rudy may have to power walk by himself. Happy Tuesday, everybody. I'm Bryno, and this is the Morning Report on the federal courts for October 28th, 2025. Please double tap your screen, hit the thumbs up, comment which White House staff member will look best in their Marilyn Monroe costume, wrong answers only, and watch the first minute right now, even if you're bookmarking for later, so people will see this. I got a few more subscribers today, so if I'm going to make a subscribers only video with the short and slightly snooty video that I cut from this morning. If you want to see it, you know how. All right, you ready? Hold on to your coffee, everybody. Let's do this. Now, real quick, I talked about Chicago Headline Club yesterday. There will be a hearing this morning. It's probably already started by now. It should be pretty spicy, but it's in Chicago, so obviously I couldn't be there, and there's no public call-in line. We'll have to wait to see what shows up on the docket. So, for now, let's peek into the DC courts. Yesterday, I attended a hearing in Smith v. Trump, which is a 2021 case where 7 police officers who were injured on January 6th are suing the Trump campaign over allegations that they incited violence and put the officers in danger. Now, this was a discovery hearing. It's about the documents the parties have to turn over and which side will turn what over and which ones won't. It's really not as exciting as some of the other stuff, but listen for a sec because this is kind of interesting. So, yesterday's hearing was about privilege, or which documents that should be turned over on all accounts the defendants are going to withhold anyway because of an attorney-client privilege or something similar. And if I work for a company or an organization and I ask that company's lawyers a legal question, that question doesn't get turned over in discovery because we want lawyers to feel free to answer those questions freely, not worry about the court seeing them later. Or flipping that around, we don't want a lawyer not to fully answer a legal question because they're worried about their own liability. But you don't get to claim a privilege anytime you ask a lawyer a question. That lawyer has to represent you. You have to be a client, and it's not always 100% clear who is and who is not a client, and sometimes even when someone is or is not a client. So that's what's going on here, and I'll use Stephen Miller as an example because he was mentioned in the hearing, but I'm making up these examples just to demonstrate this isn't actually about him. So Stephen Miller worked for the White House, but sometimes, assuming he followed the rules, he could leave his job at the White House and go moonlight for the Trump campaign. By law, you can't do both jobs at the exact same time. That's the Hatch Act. But you can campaign on your own time, even if you're a government employee. And let's say one night he was off working at the campaign headquarters and he emailed the campaign lawyer to ask a question about how much they were allowed to spend on an advertisement under campaign finance law. That might be a privileged conversation. He was working on the campaign. He asked a legal question about the campaign of the campaign's lawyers. Totally cool. That email could probably be withheld from discovery. That's pretty legit. But let's say he got called back to the White House for a late night meeting, say an hour later, and sent another email to that same person. And to make it easy, let's say the email was not a legal question, not about the campaign. Let's say he asked the same lawyer whether he knew of a good restaurant in Mount Pleasant. That email would not be privileged. But on paper, you have 2 emails from the same person to the same person within an hour of each other. One is privileged, one is not. And I think this is a pretty good, clear-ish illustration of the core issue that was kind of talked about yesterday. Because the defendants are withholding a lot of emails. And the plaintiffs are saying, we don't believe you. And the judge said, there is no way for me to figure out which of these actually are and are not privileged without looking through them one at a time, which I ain't doing. And to make things worse, a lot of people on these emails are in litigation of their own and don't want to sign affidavits in this case that may come back to bite them. So the defendants' lawyers are saying they're having trouble nailing these guys down. So the plaintiff's argument here is that the burden to prove a privilege is on the person asserting it. That means it's up to the defendants to prove they have a privilege, which, as the lawyer said, if we're here talking about it, you haven't done. The defendants are still going through and trying to make arguments sort of case by case, using discovery case law for complex cases like this, and this is a complex case. Usually you know whether or not the guy who wrote the email worked for the company or not. Here, we know they do, but only during certain hours. We have no evidence of what those hours were, so it's confusing. Anyway, that was a quick little dive into privilege and discovery. Also, I didn't know this case existed till it showed up on the court calendar yesterday, so one more for Attorney Di's closet docket, I suppose. For now, we'll have to wait for a ruling, and I'll let you know when I get one. All right, guys, it's time to catch you up on Kilmar Abrego Garcia. So, this guy has had a rough 2025. First, he was sent to CCOT, the Salvadoran prison, admittedly, per the U.S. government, by accident, and despite multiple orders by a judge in his civil case, the U.S. government refused to effectuate his return. Then, the U.S. government charged him with human trafficking with almost no evidence, and I'm not giving you my opinion there, that's according to the judge in that case. And only after those charges were filed in May did they spring him from the Salvadoran prison and bring him back to stand trial in the U.S. in June. But the trial did not go well for the Department of Justice. Surprisingly, the judge was not receptive to a criminal case with no evidence and has taken a very unusual step of allowing a charge of vindictive prosecution to move forward. And so the DOJ is kind of running out of options because, as I've explained before, if the claim succeeds in criminal court, the lawyers may well be disbarred. Vindictive prosecution is not something you want on your record. So obviously they don't want that, and they've tried multiple times to deport Mr. Abrego Garcia before his criminal case can continue any further. But his pesky civil trial keeps getting in the way. And yesterday, in a hearing before the judge in his civil trial, the DOJ admitted that if it weren't for the injunction standing in their way, they would be removing Mr. Abrego Garcia to Liberia on Friday, which is cutting it pretty close time-wise because the judge in the criminal trial has issued an order that by noon on Wednesday, tomorrow, because the DOJ is being uncooperative about producing discovery, they must provide all documents to the judge with no privilege asserted whatsoever. Not executive privilege, not presidential, not attorney-client, nothing. Everything must be put in front of the judge and he will decide what gets turned over to Abrego Garcia's attorneys. That includes all documents that reflect individuals who directed the government's change in position from deport but not prosecute to prosecute and then deport. All documents that reflect circumstances that motivated that change, and any emails between the Deputy AG's office in D.C. and the U.S. Attorney's Office for the Middle District of Tennessee. Any emails. And some other categories of documents as well. So the feds really want this guy gone before he drags them all down. Meanwhile, the judge in the civil trial has ordered she will not remove that preliminary injunction till she is assured that Liberia is off the table. She wants a clear explanation as to why Mr. Abrego Garcia isn't just sent to Costa Rica like he's requested. And the answer, for those of you who've been paying attention, is that the government only made Costa Rica an option if Mr. Garcia agreed to plead guilty to the charges in that criminal trial, which he refused to do. So government's in kind of a tight spot here. And this is getting a lot of news coverage while they're simultaneously being accused of malicious prosecution in several other courts at the same time. So it's really not helping any of their cases. They really want this gone. But let's see what happens by Friday. Okay, for our last case, we're sticking with a bit of a theme here. We've got one more criminal case, albeit with slightly less sympathetic criminal, or group of criminals, as it were. And listen up, because you guys can actually listen in on the hearing for this one today. Taylor v. Trump is another case about vindictive criminal law moves by the Trump administration, but way after conviction. So I don't have to use the word allegedly or anything here. So this case is brought by 37 former death row inmates. Not necessarily the loveliest of people in the world, but not the point. Who had their death sentences commuted to life sentences without the possibility of parole by President Biden. And when that happened, Trump was furious. According to the complaint, on Christmas Day, Trump told these men directly, in all caps on social media, to, quote, go to hell. God bless us, everyone. So upon taking office on January 20th, Donald Trump signed as one of his first executive orders an order directing his attorney general to, quote, evaluate the places of imprisonment and conditions of confinement for each of the 37 murderers, ... and take all lawful and appropriate action to ensure that these offenders are imprisoned in conditions consistent with the monstrosity of their crimes and the threats they pose. In other words, they would all be moved from wherever they were, regardless of what Bureau of Prisons had determined for them, based on the threat they posed, and sent to ADX Florence Supermax Prison in Colorado. This is partially a problem because ADX, according to the complaint, cannot accommodate the serious medical and mental health needs of some of the prisoners. But it's also a problem because we don't usually write laws or punishments that are directed at one person, or even 37 people, or at least not specific people. And I know it's not as easy to get excited about the rights of people who are actually convicted of a 187, but if you've been listening to me for any period of time, you should start to realize that any erosion of these rights can landslide. They all have to be protected, even if you don't like the people, or none of them are protected. Oh, and one more thing. The move is, and I'm not making this up, they are planning to move all 37 death row inmates to a supermax prison in the mountains on October 31st, Halloween. Meanwhile, my girlfriend Betty Sue and I will be nearby at Makeout Point talking about how good I was in the football game that evening and casually ignoring the voice on the radio of my 1960s Chevy Impala convertible. Cherry red. So, today there is a motion on a temporary restraining order, and based on the fiery rhetoric, I'm guessing this will be an interesting listen. The hearing is at 2 p.m. Eastern. You can call in and listen. There's too much drama, and Trump was way too angry about this for this not to be a little over the top. So, if you're interested, toll-free number is 833-990-9400, meeting ID 433-360-750. All right, that is your Tuesday morning report on the past day in federal courts. Again, if you can leave a comment or a like to get this out there, I'd appreciate it. Subscribe, find me on the tubes or Substack if you haven't already. Otherwise, just keep watching, everybody, and I'll keep going. Thanks a lot. Have a great Tuesday.